Thank you very much. I think Martina will introduce, and then she will give me the floor, and Dominique will interrupt me whenever he wants.
Okay, great. Let's get started. So welcome, everybody. I don't know, I see some new faces, so maybe some of you don't know how these webinars work. So we'll quickly introduce our project. And this webinar is part of the Digital Trade Integration project and quickly presents the part of the project we are discussing today, which is the methodology on IP. So regarding the Digital Trade Integration project, it is a project that we started last year. It has a broad collaboration between the UI, Bocconi University, RT School, the London School of Economics, 3 UN agencies, UNESCAP, ECLAC, and ECA. Also the ESIP think tank in Brussels and the TISA network in Australia. And also we have just received this week the last confirmation of a new international organization called the DCO, which is based in the Middle East. So it's really a broad network covering different actors across the world with the objective to create an index on digital trade integration that could be a reference for countries when they create and adjust their policies on digital trade. This index is based on a methodology which we are discussing during these webinars with the idea to have feedback from experts and keep improving the way in which the methodology is defined. So I will quickly show you the methodology that we have as of today on the topic of patents, which is actually just one entry that covers this issue. This is our short summarized methodology. There are 12 pillars in total, but the issue on patents is really in pillar 4 on IP and covers only one entry. The question we have and the areas we cover for patents is whether the application process for patents is restricted somehow. So if there is, for example, high registration costs, different terms of protections for national companies versus foreign companies, if there are also issues with enforcement of patents, and we try to take into account both the text of the regulation and the complaints by companies. And then, well, this is the only entry we have on patents. Then on IP, we cover also copyright, trade secrets, and other issues. Well, I think that's it for a broad general introduction where how we address patents so far. And we would like to improve the way in which we find restrictions in this issue, and that's why we are here today. I leave the floor to Laurent.
Thank you very much, Martina. It's a real pleasure to have all of you on board today. And in particular, we want to focus today on how patents may be or may not be restriction to a digital trade, or how the law of patents may facilitate or restrict digital trade. Indeed, Martina has shown us the first stage of our methodology. We have advanced on establishing let's say a version 2 of the methodology for patents, which precisely will be explained during this seminar and will be implemented after this seminar, thanks also to the comments of our distinguished guest speaker, Dominique Guellec, who is with us today. Dominique Guellec is the former Chief Economist of the European Patent Organization, therefore the organization that grants the patents for the 38 countries of the European continent, 27 EU plus 11 others, such as Switzerland, Norway, Turkey, and so on. Plus, he was also a senior director at OECD, in charge of precisely economic studies that are connected to innovations. And he's now a special advisor, a scientific advisor at the Observatory of Science and Technology in Paris, France. So Dominique has spent his life in patents, in innovation, and in statistics, which of course is super important for a methodology. So this is why he's the key person for us today. Despite always his modesty by saying that he's not too much the expert, he's really one of the most authoritative sources, well, not only of Europe, but of this very little planet. So thank you, Dominique, for your time, for being with us today. I don't know if you want to say a few words, otherwise I would make a quick presentation on patents and how they relate to trade, in particular to digital trade, and you would constantly, as much as you want, interrupt me, and then we will make comments on the various elements so that our methodology be the strongest possible one.
Oh, thank you, Laurent. Thank you for this very elogious presentation. Too much, but I would prefer to let you make your presentation, and I will intervene at the end so that you have the room to have some logic in your argument, and then I will add whatever is needed from my perspective on your presentation.
Perfect, Dominique, but still, if you feel electric power in your chair while I talk, don't hesitate to interrupt.
Okay. I'm still alive after this electric shock, yes.
Okay, so I shall share my screen, therefore, with you rapidly, and we will try to launch the debate. Let me put full screen. Yeah. Okay, so we discuss today patents and trade policy, and I know that many of you in this group are not too much patent specialists. I was alerted by Martina to be very cautious to really explain what is a patent beyond the recent harrow on and let's say devilization of patents. So what are they for, and why they are so interesting in digital trade. So we remember that patents are a key tool for the promotion of inventions and innovation because they simply transform knowledge into value. We have hardly any other tool except the trade secret, which has the defect of the trade secret, to transform knowledge into value. We have also copyright, but it's the expression of knowledge, whereas patents goes broader to protect applicable knowledge into value. So they are therefore crucial for trade. They are crucial for trade, and they are major indicators of innovation, of countries' competitiveness, and so on. So today, what we shall see rapidly, we shall see how patents are property titles on inventions, why patents are so important for trade, patents granting in Europe and in the world, and then the life of patents. And that connects with what Martina has mentioned at the start, at the introduction of this webinar, by saying that we, in the team of the Digital Trade Index project, we are worried or interested by patents under two aspects: at the moment of the application and examination, and then when the patent exists, how the patent and litigation on patents may be elements that facilitate or that slow down digital trade, or to be more precise, how digital trade may have effects, support effects connected to these issues. So this is why I try to develop this small presentation in the current way. We are starting with how patents are granted, and then we are discussing how patents do live and do die. So we remember, and we should remember that intellectual property, if we can call them a real property, in the definition, which is the WIPO one, therefore the United Nations one, and the one adopted more or less by practically 200 countries of the world, the intellectual property rights are property titles on creativity. And in the case of patents, this is a property title granted by the state. So as any property, material or immaterial, the title is granted by the state. And they are granted to protect inventions. But it's a property title with some limits, such as the public interest. Like any property title, a physical property title, if I have a house and there is a need to enlarge the street in front of my house, the garden may be subject to expropriation, or even the house itself. So a property title with limits that are the public interest. Patents, okay, are a major source of value for companies, for economic operators, and for their activities. And then we see that this economic value of the patents depend deeply on policy measures, what interests us today. And these policy measures have an influence at two stages: for the granting of the patents and for their enforcement. And our methodology, or the revised version of it, is trying to take into consideration the importance of the granting system of patents. Are foreigners discriminated in a country because they are forced to take a local agent or not? Are they discriminated because still in a few countries they are subject to higher fees for the registration? Is the country not much internationalized? We'll see that later on, by not adhering to international treaties that facilitate granting. How is the granting made? Through a substantive examination on the substance of the invention, or on mere and light formalities? So that's obviously one element that has an influence on the economic value of a patent. A patent which is not checked is not a patent that has a high value, possibly. And of course, the economic value of the patent depends on a second aspect, which is the enforcement. Does the legal system of the country permits to enforce in an effective way the patents that is obtained by any economic operator? And under what costs? For example, we know that the US has a fantastic system of enforcement, but this system is awfully expensive, which is also a way of deterrent to some categories of patent owners or applicants, such as universities. So clearly enough, companies also use patents to defend their inventions or to sell their inventions, to promote them. So the strategies are defensive, a fence around my invention, or on the contrary, a label on my invention, a patent, that guarantees its new aspect and inventive aspect and permits that it be sold or given for hiring through licensing. Clearly enough, because among the intellectual property rights, the patent right is one of the most effective ones. And this is why business tries, and some states try to push for the extension of the patentable subject matter. This is the case, for example, of the United States of America, that have permitted the extension of patents to software in the US. So in theory, not in Europe, but though it came back in Europe from the back door. So the tool is so attractive that the haves try to expand it, and the have-nots may have other views. There is currently a fierce debate on artificial intelligence and patents. We could do a whole webinar on this. This is not the purpose of the webinar today, but still we need to touch it. Can an inventor be a non-physical person? Can it be a machine? And what is the danger, the ethical danger for society? Artificial intelligence is in any case present in many patents because inventions are connected to operations that are sometimes made by the machine itself through machine learning. Then artificial intelligence gets used by the patent offices in order to speed their work in analyzing the patents. So there are many, many aspects also on the extension of the topic. And this is why with Martina, we think it's so important to dedicate a webinar to this topic. The second element that affects currently the patent matter is internationalization and policies. Clearly enough, internationalization of policy, basically all countries, by joining the WTO or by being in WIPO, get norms that are not that far one from the other. And of course, this helps considerably our researchers who work on establishing an evaluation of the patent-friendly or not patent-friendly environment for digital trade, because there is a large internalization of norm setting, and our methodology considers this. A third point that our methodology doesn't consider that much and probably cannot consider that much is the issue of the respective needs of the developing countries, of their specific needs, such as health issues and tech transfer. Is the patent system impeding development or not? And this is something that is not really currently considered, but on which perhaps at a later stage of the project, of a project or another project, something should be considered there. Connected to this, there is self-evidently the issue, the health issue and access to medicines. The adventure of COVID, including in medicines for treating COVID, and in addition to this, the vaccines against COVID, shows that we are all developing countries in terms of health. We all realize that even the richest countries of the world are maybe without the right tools, and patents as restricting access to medicines is an issue that has been probably debated and that all of you have really heard about and followed over the last months with personal worry and intellectual passion. So these are the current challenges. Very quickly, and I just show this slide for those who are really not in the IP family and know very little about it, and so that it remains also in our EUI Bocconi archive. We remember that an invention to be patentable should be in the subject matter of the law, but this is not very problematic for our methodology since most of our countries are WTO members. So everything is patentable except what is excluded in the law, such as treatment methods, mathematical formula, games, possibly human life, animal life, and varieties of plants. Okay, an invention to be patentable should be industrially applicable. Why? Because science could not be hijacked in theoretical science. An invention should be new, which means not new. It should not exist. And thanks precisely to databases with tens of millions of documents and also artificial intelligence, it is easier for a patent office than even 5 years ago or 10 years ago to determine whether an invention corresponds to something that exists already because of the internet connection between the IP offices of the world. The invention should be not obvious for an average specialist in the field. In addition, the invention should be sufficiently disclosed in the patent application so that possible clients can understand what there is in, and also so that researchers do not reinvent the wheel. On these 5 criteria, most of our countries are harmonized, and we don't need for the methodology to move anything there. Whereas in the country, in the examination and in the applications, there is a lot to say. So the rights are registered. They are registered, and there each country has a different framework. There are fundamentally three frameworks. Patents are granted, let's say, applied in a state for the said state. Okay. Then there are two international systems. There are regional systems and worldwide systems. The worldwide system is called the PCT, the Patent Cooperation Treaty. We have, Martina and I have included it in our methodology. This is a system that is run by WIPO that gathers more than 150 countries and permits through one application in your country to request protection for the entire world. Well, for the entire 150 countries. Clearly enough, those who are not in our methodology have a bad point because they are not internationalized enough. However, the PCT doesn't grant patent. Only countries or possibly regions grant patents. The PCT application permits to launch a patent application that is valid in a series of countries, but it is after complex preliminary search, preliminary examination that lasts 30 months, that the file arrives to the member state of the PCT, to each member state of the PCT, where the applicant wants to go. And there is the substantive examination, if there is one, or not, the formal examination, and the patent is granted. So whereas the application is international, the granting remains national. Yet it facilitates tremendously trade. And this is why Martina and I wanted it in the methodology together with our younger colleague, Ruben. Okay, so fundamentally, this is the idea. The regional systems is a medium way. There are 4 regional systems that interest us for the time being. Only 4 are existing and effective. I would call first the 2 African systems, the OAPI one for French, English, and for French, Portuguese, and Spanish-speaking Africa. There is only one Spanish-speaking country in Africa, Guinea Equatorial. But it's basically French and Portuguese sub-Saharan African countries. There is the ARIPO one for most English-speaking countries of Africa and Sudan. There is the Eurasian one, which comprises the former Soviet Union. It's headquartered in Moscow. It comprises the former Soviet Union with the exclusion, of course, of the Baltic republics since they joined the EU, of Ukraine, for evident reasons. But basically, this covers the former Soviet system. And then there is the last system, which is recognized all over the world as being one of the most effective one, the one of the European Patent Office. That groups 38 countries of Europe, all the 27 EU countries, plus, of course, the UK, Switzerland, Norway, Iceland, Turkey, all the countries, let's say, I would say, again, in these days, free Europe. And as such, the EPO system is an integrated system under which the patent is applied either through the national office or directly at the EPO, which is headquartered in Munich and The Hague, with 2 small branches in Vienna and Berlin, and a very, very small office in Brussels, but basically it's Munich plus The Hague. And the EPO does something which is one step further than the PCT. It substantively examines the patents and grants the European patents. It grants the European patents, but the day the European patent is granted, its European character evaporates, and it transforms itself into a bundle of national patents that must be in many countries validated. Still, there is, contrary to the PCT, which is just a launching mechanism and a pre-examination or a pre-procedure, the EPO grants European patents. So this, like the ARIPO, OAPI, and Eurasian system do. So these are the three ways to get a patent. Clearly enough, and this is for those who work on the methodology in their everyday life, the most the country is in systems, in particular the PCT, the most the country is internationalized and therefore digital trade friendly for then trading on inventions. Now, national laws, we should remember that national laws establish the patentable subject matter as well as the 5 criteria. And this is why we do watch them. We do watch them mostly on non-discrimination of foreign applicants. Of course, there are international principles, as we have seen, through the WIPO Paris Convention and the WTO under its compulsory chapter, the TRIPS agreement. National law, above all, establish the examination system applicable, which is formal or, well, formal and substantive, or formal only. What does it mean? If the examination is only formal, I check that Martina is Martina, that Martina has paid the application fee, that Martina really lives in Florence, has sent a file which looks in order. Possibly there is always a security requirement. So at the Italian Ufficio Italiano Brevetti Marchi, at the Italian Patent Office, there is a very small military unit that checks that her patent application before publication doesn't threaten national security of Italy, and this applies in all countries in the world. And that's it. After a certain time, the patent application may be published if she doesn't choose to have substantive examination, which is now possible for Italy. But if she doesn't do it, the application is published, and then the patent is granted. Therefore, the weight of the defense of the or the criticism is on the patent is on enforcement. Other countries, such as Germany, the United States of America, Russia, China, but also some other countries in the world, have opted for substantive examination, which means also checking the famous 5 criteria that we have discussed. And therefore, these patents have, though they are called patents, have a higher value. The European Patent Office grants patents after checking the said criteria, which means that its patents are of high value. So these are these 2 methods. What we have discussed with Martina is that, okay, most countries in the world do the formal examination, so a few do the substantive examination. We are checking that there are no complaints of low quality of the substantive examination. This is one element which is very important because low quality of formal examination normally doesn't happen. So we are controlling in our methodology that there is no discrimination of foreigners, and if there is substantive examination, that this substantive examination is made in accordance with certain quality elements. Of course, it's very difficult to do it. So on that, we rely on reports, mostly from professional associations or so on. In particular, I will give a very negative example. I went a few years ago, but that was in international capacity for an international organization. I helped the country redoing its patent law. That was a very small country a relatively small country in Asia, in a strategic position. And in this country, we had a patent law that was very old, and that established that patents were examined by a group of 7 examiners. So all patents of the country were examined by a group of 7 people all patent applications, who of course couldn't get the experience, couldn't have the experience in all fields of technology to grant properly patents. And of course, this was very, very negative. So better no substantive examination than a bad one. Okay. So in some countries in particular, and I alert the researchers that who listen at us today, in some countries that were under British domination, there are sometimes very, very old British laws that establish substantive examination with very limited committees without resources of examiners. And these committees, of course, cannot really perform any interesting substantive duty. 7 people cannot examine the patents that are applications that are received by a country. So consider that the EPO has, Dominique will correct me, what, 7,000 employees?
Including 4,000 examiners.
Okay.
4,000.
4,000 examiners.
Yeah.
So clearly enough, okay, this is the European continent, but with 7 people, you can't examine technology. Okay, so it's worse than having nothing because you are giving a guarantee that is a false guarantee. And that's interesting for our methodology. Now, of course, what is very interesting for us is that the most the countries are in international system, the best it is. So access to the PCT is very important for us. And these are the international granting routes. I don't want to keep the floor too long, but we should remember that the patent life, which is licensing, litigation, is always subject to national laws. If very soon we have a community patent, the EU patent without Spain and possibly Poland, we will have something under the court of justice, well, under a special court, but something centralized. But normally the rights are in any case granted, their life is national. And that's where our index has also a major value. So the licenses have a lot of importance. And we know that there are 2 types of licenses. The compulsory ones on products that are compulsory, products or processes, such as, this may apply to medicines. This is one of the big debates of these days. Or the licenses are voluntary. Just one quick word on the compulsory licenses. Compulsory licenses that are very often so much criticized, including by big business and by pharma, were largely used by some countries that are now not much in favor to them, such as France, Belgium, Italy, countries that used them until the 1950s, 60s to produce medicines. Voluntary licenses are clearly licensing contracts. By license, we are talking simply of the rental right, like a rental on any property. And the laws, but this is very tricky to examine, the licensing laws are made at national level. Some laws are very restrictive. They impose a lot of burden. For example, until recent times, China forced people who did, companies doing voluntary licenses in China. So any company, I don't know, any Volkswagen, a car maker, makes a licensing agreement in China. The Chinese licensee is allowed to sub-license the technology. Was allowed. It was compulsory in the law, in the Chinese law. So there is a lot of importance on the laws of voluntary licenses. And clearly enough, licensing contracts are essential tools for technology transfer. We should not, by the way, demonize China. European countries and others did the same when they were at a certain stage of their cycle of innovation. So we should be cautious on this. Now, we should remember that the patent owner is, we used to say that the patent owner is his own policeman. So it's a private right, granted by the state, but a private right. This is why it's so important that the patent drafting be of high quality, and that the licensing contracts do not impose the famous restriction burdens. I know that we have colleagues connected from Latin America today, and I'm very happy to see them. And for example, I personally had the occasion to help various Mercosur countries, in particular Argentina, Paraguay, and Uruguay. Chile had more modern laws to limit the restrictions they had in their licensing laws that imposed so heavy formalities to licensors. And that was clearly enough a burden for basically for investing in Argentina and transferring technology. So this is something that is quite important to consider. Then, of course, litigation is a choice of the parties between national courts and arbitration. But I don't think for our methodology we go that in depth in these topics. Okay, there is one topic that is really an open agenda, and we should consider at a later stage with the project partners, which is the flexibilities, including on medicines, on health, and also issues connected to patents, biodiversity, traditional knowledge, UN Sustainable Development Goals, where there are some there is some connection or short circuit, since we talk of electricity. There are some short circuits with other conventions, in particular the Nagoya Protocol, that imposes some disclosure obligations on patent applications and patents, and some ownership rules in favor of indigenous communities. There is no doubt that the classical system I presented today has some shortcuts with other issues connected to sustainable development. But on this, I don't know if we can include it in our methodology. This is a study in itself. I just open the question, since this is the only webinar we dedicate to patents. I still want, if I may say, to put it in the common plate today. Well, basically, this is all what I would wish to briefly say. I hope that I have not taken too much time for this introduction, but I'm really open to questions. But above all, we have the very special honor to have Dominique with us. So Dominique, you wanted to comment, or perhaps you would comment first and then we take questions.
Yes, thank you, Laurent, for this really encompassing introduction. I would have really nothing to add regarding the overall economic picture of patents and so on. So I will add just a few points on relating to the issue today, that is patents, digital matter, digital trade, and protectionism in a way. So first, two sort of generic remarks on patents and protectionism. You put your finger on it at the end. I mean, a key issue in our world today is enforcement. Because with the PCT, the WIPO, WTO, there is really a straitjacket on the patent procedures, even not completely, but to some extent, the subject matter and so on, the patenting criteria and so on. So what is left, and where countries have a margin for maneuver, for good or for bad, it's about, it's about enforcement of all these rules, enforcement within the patent office. But again, these procedures are fairly standardized, but enforcement in front of courts. And this is another matter, of course. The same law can have or uniform law can have let's say, asymmetric aspects, impact on the various categories of users, citizens, businesses, and the like. If you're a Korean firm and have to go in front of a jury in Texas, in a small town in Texas, to defend your IP against a big Texan company, well, good luck. That's the same law, applies to everybody, but popular juries have some tendency to, well, they don't necessarily have the technical skills to look at patents, but they might have some, let's say, cultural preferences. So this is uniform law, again. So enforcement is key. Or if you have to go into a completely opaque legal system, judicial system, like in China, to put again a name on that, well, good luck as well. It's a question of skills of the judges. They don't necessarily understand what the matter is about. And it's also about other considerations than the purely legal ones that they can have in mind for political reasons or others. So enforcement is a key aspect in protectionism. Second, there is a smaller one, which is fees. Patent fees normally don't discriminate against foreigners, but you might have, of course, sort of indirect ways of doing that, like these small entities, special fee in the US that essentially reduces gives a discount of 50% to small entities, so SMEs, universities, and so on. If you're a European small entity, you're not eligible to this to this discount, and there was the question at the EPO at the moment of setting up such a measure at EPO, but it turned out that it would be illegal because it in the European context, because it is a sort of subsidy to businesses, and the EPO is not entitled to subsidize businesses. So there might be a way of doing it that would be at the national level. National government might refund 50% of the fees of the businesses and so on. So again, that's an interference between patenting and trade. But let me go to more the core of the subject, which is with the digital trade. I want here to raise three points. First is data. In the context of digital trade, it's difficult or even impossible to separate data issue, data property issue, data control from other aspects of intellectual property, notably patents. And just to take probably the most prominent example, but there are others, machine learning, which is, of course, the technology that everybody's talking about today. Well, not the only one, but one really of the the fast advancing technologies, machine learning. So technology here is about both some software, but it's mainly about training your software. And how do you train your software? You train your software on data. So it makes no sense to put a patent on a machine learning system if you have no control of the data. It gives you control of nothing, essentially. And of course, you have the symmetry. If you control the data, you don't care that much about the AI technology per se. I mean, you can find it off the shelf wherever. You can train it on your data. That's where the key issue is. And we know that data are extremely protected for good reasons. Think of GDPR, privacy, health data, and so on. But sometimes the protection might be going beyond these good reasons, and there might be some trade ideas in mind of the people who are protecting them. So the first thing is data protection and patents are really intertwined in the digital world. Second, standards. Standards, which I guess you are going to have a look at in your context. Standards are important in all industries, of course. You mentioned, Laurent, the automobile industry. In the automobile industry, patents are key. But probably the one industry in which patents are the most important is all the digital industries. It's all about compatibility, interoperability, and the like. And if you control a patent which is core to a standard, it gives you enormous leverage on your competitors. So that's another thing to have in mind, the interplay between standards and patents in the context of digital trade. We see, by the way, in the current trade war between China and the US, which started many years ago as a sort of, let's say, low-frequency war in a way. The Chinese have been active for nearly 20 years, progressively setting up their own standards. With the technology and the protection of this technology that goes with it. So they've been preparing for the current situation for long. But yeah, it's difficult to separate patent from standard in this world. And last issue that I want to underline in the context of digital trade might seem a small one. It's 3D printing. 3D printing might be seen as a niche. Okay. Not sure that it is only a niche, but it's true that it's not that big today, but it is growing fast, first. And second, it is most important in really key industries because, well, in many industries, but in key parts of the production of the value chain, because that's where the most sophisticated spare parts are, how to say, fabricated, manufactured or sculptured, printed, in fact. So 3D printing, it's about really printing these tiny or not so tiny parts that have very strange shapes and so on. And what is specific with 3D printing is that a product, the one that is to be printed, is reduced to computer code. And computer code can travel very easily, as you know, in much more easily than can the actual physical parts. So you can cross borders with computer code, that is, and you will have no border police just controlling for it. And that's an issue for protection in general. It's much more difficult to protect that. Just ask musicians when music was digitalized 25 years ago or so with the early internet. It was the end of the recording industry as we knew it before. The recording industry never recovered from the digitalization of music. Now there is a new music industry with new business models that have gone back to life. And I'm not saying that the whole manufacturing industry will follow the same trajectory, but well, parts of it might. If the manufacturing industry is digitalized, and then that will raise the issue of IPR. How do you protect, how do you enforce protection on the digital manufactured products? And that has special impact, I would say, across borders, where the legal regime might differ, when there might be some biases, there might not necessarily be, let's say, friendly considerations between countries when they take their decisions and so on. So this is the point I wanted to just to put on the table for your reflection and for your trade restriction index. Thank you, Laurent.
Thank you so much, Dominique. Thank you also for opening new or additional avenues or avenues that we should that we have already covered, but that we should connect also with the chapter on patents. Thank you so much. Any question from our audience? Martina, of course.
I do have some comments and questions. I don't know if there's someone else, but maybe I can start.
Yes, please launch the debate.
Okay. So I have several points because this is really an area that I'm not fully familiar with. So I've just come across some of these issues. One question I have, and it is actually for both of you, is regarding software, because this is for sure one of the most important areas for digital companies. And for what I understand, there is also the possibility to use patents for software. But what I knew was that software was protected by copyright. That was my understanding, at least talking with startups. So I wanted to ask you, how does it work in practice? And if there is a difference, if you feel that one of the two provides better protection to a software. And then the other thing is I had just throwing there another issue is since Dominique has spoken about standards, there's been a discussion on this standard essential patents on that apply also in a lot in internet standards, digital area. On this, do you feel that we should take this into account in our methodology, and if so, how? Because I wouldn't know if how we can address this issue and if there is a problem there, or how to take into account the fact that patents and standards go together and should be treated in some cases together. And the last point is about the 3D printing. Because this is an area that I know a lot about because I'm very close to 3D printing startups. I teach 3D printing to students, so I know 3D printing very well. Regarding this, I like these fears on 3D printing, I think are already there since many years, at least since 6-7 years. But they have never really materialized, and 3D printing is one of the things that is holding developing countries back when it comes to taking commitments on data. I wonder, like in practice, what could be the problem there? Because what I see is that it is easy to replicate some parts through 3D printing. So some parts of automobiles could be easily replicated maybe, but when it comes to patented products, they should be complicated. Like, I guess they are complicated to replicate, and the 3D printer, a good 3D printer of metal, for example, costs $200,000. So it's not something that everybody will do. It will really require proper work to infringe a patent, I think, through a 3D printer. So yeah, I just wonder how do you think this can create a problem in practice? Because I don't see how this could happen. I see how a person could replicate something at home easily, simply, but not really create a huge problem for a company. Yeah, these are just some thoughts.
Do you want me to start, Laurent, or give some thought? Laurent? Well,
I think he's blocked.
Oh, yes, oh. Yeah, that looked like okay, so sorry for him. So giving him the time to come back. No, I fully recognize that your 3 points are important and extremely relevant, and I don't have any definitive answer on any of them. On software, you're right, there are 2, even 3 ways of protecting software, and even more. There is patents, there is a copyright, there is trademark as well, which in certain cases is more important, and they are complementary to each other. What the copyright does, it protects really the expression, it protects the code. So it does not protect the idea which is behind the software, and that's what the patent is supposed to do. So they are complementary to each other. What I hear from people from the industry is that first, it's important to take patents in that when you can, but it is not the major issue in this particular industry. It's not the way that you will make the more money. It's a way, if you want to grant licenses and so on, it helps you formalizing, or it's a sort of background for such contracts. But for the rest, I mean, you look at the most valuable software, I don't know, Windows or whatever, patent protection does little to it. They have patent protection, a lot of patent protection, but it's not even without patent protection, they would be very rich. So there is complementarity between the two. On standards, I'm not an expert in standards either, but there are national officers that are in charge of standards. So that would be worth having a look at that, at their practice, and so on. I'm fairly sure that when it comes to digital products, in many cases, there are global standards and the ISO and industry is taking care of all that and so on. But if we look at certain industries, there is really a sort of imbalance between countries in their representation in the industry. To my knowledge, the so-called the GAFAM or whatever, they all come from one country. If you add the BATs, you have two groups coming each from one country. So what they do might not be considered as protectionism per se, as it is not a state doing it, but that might raise still sort of political questions. So I don't have specific ideas in this topic, but I feel it's worth looking at it, even from this industry angle. And finally, on 3D printing, you visibly know much more than I do. As I said, it's really a niche at the moment. But I suspect that it is getting more important. And there are key parts in the aeronautic industry, spare parts for big machinery, including nuclear power stations, which are coming back to life, apparently, manufacturing. Well, for such manufacturing operations, 3D printing is and will be key. So it's a sort of, and you have increasingly big 3D printers. They can print things which are 5 to 10 meters long. So it's really not the sort of thing that you have at home, certainly, but it is the sort of thing that can make infringement a very valuable activity, I'm sure. So it's worth having a look.
Yeah, many thanks. Yes, Gabriele, right? Because I always I'm very bad with names.
Yes, no problem. Yes, Gabriele. So first of all, thank you very much, Mr. Guellec. So I'm Gabriele Gaiani. I'm the co-referent for the project at Bocconi University, together with Professor Manderieux. Yes, I just wanted to add that I think that, of course, if we consider just the digital market, 3D printing may not be a problem. But if we take into account all the, what we may say, mechanical type of inventions, right? Really the basic of the patent system. So there, just to complement reality what you were saying. So even besides the aeronautical industry, right? If we're thinking just about mechanism, right? The typical patent that we had in mind before all the digital or chemical, right? I think that in that sense, it may be huge, as you were pointing out, but of course there we have to distinguish the sort of the type of market we're thinking about, right? So one would have also to, and this certainly Martina is better placed to make a sort of economic analysis in terms of how mechanical inventions or mechanical patents, what is the share of the market in terms of value and production. But there I think that there may be a big problem, because that's exactly the type of thing that 3D printing does. Not digital things, but reproducing mechanical stuff, right? So the classical patent.
If I may just add one thing in that regard, the fact that 3D printing now, to my knowledge, and Martina might confirm it or not, is invading the chemical and the drug industry. You can 3D print drugs. And drugs, that's where the money is, as we know. So certainly, most sophisticated drugs, it's not for household 3D printing activity. But there are many sort of basic drugs that still make quite a lot of money, that it could be worthwhile, infringing.
Well, Laurent is back, but just to add on this, well, I think like my perception on this is that like the value added of 3D printing is not as big in terms of copy. Like you could still copy without it. It's just an extra tool that you could use if you really wanted to copy something. When it comes to maybe airplanes and aeronautics, maybe there is something there, but this is really high scale level of coping with method 3D printing. And yeah, there could be something there. Just my fear is that this is being really countries in general are seeing this problem is very big, but in practice, as of today, it is not at all, and probably it will never be. Like we will see, but I think it's creating more fears than it should, in this sense. Laurent is back. I don't know if you wanted to say something yet. Can you hear us now, Laurent? Yeah. I don't want to make this like there is also a comment on medical devices. I don't want to make this a 3D printing webinar, but yeah, on medical devices, it is the same. Laurent is back, but as of today, the main applications are mainly in dental. And in that case, I mean, the 3D printer could never be used to infringe a patent. They're just another mean to create new type of services. Yeah, I will leave it there because it changes topic. And maybe I have another question, since still it seems Laurent is not fully connected, about enforcement, because this is a big problem we have with the index, that for us, we have to take into account the fact that we have to find the data for this. And when it comes to enforcement, Laurent was saying we need to use the reports from professional organizations. But I wonder if you also have other ideas, other things we should consider in our analysis when we look for information in our 90 countries that we are looking at now.
Well, I think that in many countries, court decisions there are databases that are accessible, but 90 countries means probably 70 languages or 100 languages. I'm not sure. There are countries with more than one language. And well, this is typically an area where there is no translation or very little translation. So you will have to go through that probably, except if you can find people who have already done some of the work. I could share with you, I think the WIPO has done some work in that area. I will share with you some references on that. So it's not going really into the actual record of course, but well, listening to what professionals, with the opinions of professionals, this sort of thing.
Great, thanks.
Can you hear me, Martina?
Yes, we can hear you now.
Yeah, I think this is, and can you see me? There was, I don't know why I was expelled from the meeting, very involuntarily, of course. So I couldn't see anything and I couldn't talk at a certain stage. I think that Dominique points out a very important issue there. And indeed, that would be good that if he shares this with us.
Yep, absolutely.
Okay, excellent.
I think, I don't know if Alejandro has a question or not.
Yeah, Alejandro, please.
Oh, thank you. Well, first of all, thank you, Mr. Dominique Guellec. I'm sorry if I'm mispronouncing it. And yes, I was thinking about how to measure enforcement, because there is a legal perspective that we have addressed, but there's also like a more economical perspective. And in a way, I believe that there's a challenge for our methodology regarding how to score enforcement of patents in an interdisciplinary way, or from like interdisciplinary scoring or measuring. And there are several things we could take into account. For example, I was thinking about cost of opportunities, that maybe a long process, a legal process, can imply, like if the process takes too much time, or I was thinking how about this. It's more like an idea that how to get an effective interdisciplinary measuring of enforcement. And maybe if you could give us some idea you have, some advice, it would be great for us as researchers.
Well, that's a difficult question. I think there are various approaches or types of data that you can exploit in this field. There is, which are sort of interrelated. One is about the rules. There are rules across countries, and which are quite diverse. There is in the US, you have out-of-court settlement. How do you take that into account? Because it means that many of the sort of implicit decisions of courts, as anticipated by people involved in the case, they will have impact, but that will leave no track record. Well, just you will know that there was an out-of-court settlement, full point. So how can you interpret that? How can you exploit that? Very difficult. But there are in many countries, as you said, the duration of the procedure might matter, the cost of the procedure. We know there have been many studies that show that the higher the amount of money that you put in a case, the higher are your chances to win it. Okay, it's not mechanical, and you don't buy courts in most countries, but still you will buy more lawyers, a bigger pile of documents to serve your case, your cause, and so on. So, well, there are asymmetries in wealth, and they are reflected in courts' decisions. So, but more or less across countries, because the systems might differ and so on. Might be the discovery system that opens the door to whatever you want. So there are all these rules whose impact is quite uncertain. So might be either you go through the files and then, well, it might be a bit biased because there is this out-of-court settlement, and it's costly because across countries you don't have the same languages and so on. But the other thing to do, and I'm sure there are inquiries about that, surveys of professionals, where in which people are asked, could be attorneys, could be business people, whatever, are asked a number of questions on the legal system of countries. And this is notably used for sort of informing companies' decisions for cross-border investment and where should I locate my R&D facility, blah, blah. So there are data sources on that. I'm not sure whether they are free. Some of them might be. I don't know what the best are, but yeah. And there is finally, so the WIPO has done a sort of, at some point they did an inventory, a reasoned inventory of laws in countries, and not only laws regarding patent procedure, but really enforcement. So I don't know whether they've kept updating this survey, but it is certainly the type of data that you can think of a reasoned way of aggregating, quantifying, and introducing into your own index, if it is there.
Great.
Thank you, Mr. Dominique and Mr. Laurent.
Thank you. Dominique, are you there, Laurent? Because we have really like 3 minutes to go to close the webinar. And I saw one comment from Leon. So I don't know if Laurent is on there. Leon, I just wanted to, I saw the comment about the injunctions. Do you perhaps want to provide a bit more context? Because it is also very interesting. And we were considering to include the use of injunctions as a restriction. But...
Yes, I can reply. Or Dominique, you want to reply?
No, go ahead, Laurent. Go ahead. It's your
No, go ahead first, and then I go ahead. I don't know why my camera is closed by Mia. Is there a way to open it?
Yeah, you can click again. Sorry, because we were looking, we're not seeing you. We were seeing the other side. Okay, try to turn it around.
Can you see me?
You have to turn it.
Okay, I did it.
No, now it's closed, I think.
Okay, because normally it works perfectly. This is the first time I have the same problem. Okay, fine. But this is not so let's Dominique, let us make Dominique talking first, and I would complement. I would add if
go
there
ahead,
is.
Laurent, go ahead. I talked enough for that. I don't have much to say on this issue.
Yeah, so I think on the question of Leon, which is a very essential one, it is very important in our methodology that we consider the way in our countries we can basically we can consider enforcement. So in our methodology, this is something that is very important. The only problem connected with Leon's question is that we need absolutely to have to take the questions exclusively on enforcement through basically what professional associations or US Congress Section 301 tell us. Otherwise, we cannot really really have any other relevant, let's say, relevant source, because how can we measure the possibility to make injunctions or not? This is something that is quite problematic there.
Yeah, on this, just adding a piece to the discussion on trade, on digital trade. I've read that the use of injunction could be considered as a trade restriction, because in practice, when a court is allowing an injunction, it is blocking the import of a digital product. And so this might also be abused in certain cases. So it could also be seen as a restriction to digital trade. So it is a bit complicated, the issue of injunctions, and could be abused in some countries potentially.
Exactly. So this is something that perhaps that should be further discussed, since clearly enough, this is, as Leon has pointed out, in other fields, injunctions may be also a way, an abusing way to block fundamentally block trade. So this is something very important, on which, by the way, my colleague, Professor Galliani, is connected, has worked about. Okay. Any additional comment? I'm sorry that I have lost 10 minutes of the webinar, but it will be registered, so I shall be able to hear what has happened then. And now that Mia has brought me back, I really wish to perhaps take another question if there is any. Any additional question? No? Martina?
No, for me, it is all clear. So we have several things to take into account for the methodology.
Okay. So at this very stage, I think I should really warmly thank all the participants to the meeting. I really wish to thank Dominique Guellec for his time, for his energy, for really giving us also new avenues and new food for thought, such as in the topics of data standards and 3D printing, on which we shall really work further in the jointly with Martina in the coming days. Thanks to all of you. Perhaps I'll stay connected 1 second more with Martina, just to check, as we have another webinar, this technical issue. And I really thank all participants for their time, energy, and dedication.
Thank you very much.
Thanks, everybody, and thanks, Dominique, especially.
Thank you, Martina. Thank you, Laurent.
Dominique, un immense merci.
Thank you. Bye.